Are you tired of seeing your hard-earned credit score crushed by a bankruptcy that should have already been fixed? You've likely watched other videos and read guides that only scratch the surface. This one is completely different. Here, you'll get every legal and strategic angle in one place. No fluff. We'll walk through each step of the Fair Credit Reporting Act based on my removal strategy and explain why bankruptcies hurt your credit score and show you the PACER data flows through LexisNexis and LCI and reveal insider tactics that can force the removal of the bankruptcy that's on your credit report. And by the end of this video, you'll know exactly what to do and when to call in a credit attorney for backup. Let's get started. Bankruptcies can completely wreck your credit score and stay on your credit reports for 7 to 10 years. But how did that bankruptcy get on your credit report in the first place? When you file for Chapter 7 or 13, the court creates a public record in PACER. That's the federal court database. Third-party companies scrape that PACER data and feed it to the credit bureaus. In fact, Equifax and Experian get bankruptcy info from a data firm called LexisNexis, while TransUnion gets it from LCI, Lundquist Consulting. These firms match your name, address, case number, and partially your SSN, DOB, and supply it to the bureaus. The results, even though bankruptcy courts do not report to credit bureaus like they say on the paper you probably got, your BK ends up on your report anyway through LexisNexis and LCI data feeds. This data flow actually creates a legal opportunity for you. Under the Fair Credit Reporting Act, all information must be fair and accurate. Rule 9037 of the federal bankruptcy rules requires courts to redact Social Security numbers, full birth dates, and other sensitive details from PACER. That makes it nearly impossible for LexisNexis or LCI to be 100% sure the case belongs to you. If they can't verify an entity without your actual SSN, date of birth, FCRA says that the disputed info must be deleted. In short, every missing or mismatched detail in your BK listing is a fightable error. The Fair Credit Reporting Act, FCRA, is your friend here. It limits bankruptcies on your report 7 to 10 years and gives you the right to dispute any inaccurate or unverifiable entry. Specifically, 15 U.S.C. Section 1681I says that after you dispute something, the credit bureaus must promptly delete it. Any item it can't verify. Creditors and furnishers, like LexisNexis and LCI, also must not report known errors. In practice, that means you show that the reported BK data doesn't match your actual records. The bureaus have no chance but to remove it or correct it. Rule 9037, redaction rules, works in your favor too. Since the court's filings omit your full SSN and birth date, a bureau or data firm can't check those against your identity. Without a way to authenticate the record, it's considered unverifiable underneath federal law, and just practicality. And logically as well. Once a disputed item is unverifiable, FCRA requires deletion. We'll use this leverage at each step below. Follow these steps carefully. They cover both credit bureau tactics and legal angles. We'll point out where to cite FCRA statutes and relevant rules. Pull all of your reports, both primary and secondary. Order current credit reports from Equifax, Experian, and TransUnion. You're entitled to free reports at annualcreditreport.com or via paid services. But don't stop there. Also get specialty secondary reports like we mentioned before. In particular, request your LexisNexis Consumer Disclosure Report and any TransUnion LCI report as well. LCI is TransUnion's BK data provider. These show exactly what LexisNexis and LCI have on file for you, including any bankruptcy records. Having these reports lets you see the raw data as supplied to the bureaus. Document every inaccuracy or discrepancy. Go through all reports line by line. Compare details against your own documents, discharge papers, schedules, credit cards, statements, etc. Look for misspelled names, old addresses, or wrong birth year, incorrect case number, chapter, or filing/discharge date. Any sign of multiple cases or residual open bankruptcy entry Debts reported as still owing that were actually discharged, FCR states that those must be corrected. Write down every mismatch. Because of Rule 9037 redactions, focus on your factual details you can verify, like your name, the spelling of it, SSN last four, and your address, of course. Even a small error is a chance to force a deletion. Remember, LexisNexis and LCI match on name, address, and partial SSN. If any of those don't align exactly, you have room to dispute them. Dispute with the credit bureaus by certified mail. Now, draft dispute letters to each bureau listing the errors you found. Do not use online disputes unless you're an advanced player like myself. Online disputes are somewhat challenging for noobs or amateurs. So don't use online dispute portals. They often auto-dismiss complex cases like you may have and give you no legal record if you don't know how to really use the portal to begin with. Instead, send a detailed letter by certified mail. Return receipt requested. Keep copies, of course. In your letter, identify yourself by full name, SSN, last four, of course, and account number. Then quote each error on your credit report and explain why it's wrong. Attach photocopies of supporting documents, bankruptcy discharge, credit card statements showing zero balance after BK, etc. Demand that the Bureau reinvestigate under FCRA 1681I, under 1581 USC 1681I subdivision A 5A. If they cannot be verified, they must promptly delete them. Because this bankruptcy case cannot be verified with certainty, you are required to remove it. Signing and dating the letter adds formality as well. Okay, you gotta go. I'm recording, okay? You should go to your mom. Go, 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 go. Signing and dating each letter adds formality. Now it's time to handle their response, the verification process. By law, the Bureau must acknowledge your dispute within 5 days and complete reinvestigation in 30 to 45 days. In practice, they will either delete the BK or send a verification letter saying it's been validated. If they delete it, congratulations, you've won. If they verify it, don't stop there. Carefully read their response. They will usually cite LexisNexis for Equifax and Experian, or LCI for TransUnion, and claim the court verified the information. In reality, courts don't do that. Send a procedural follow-up letter to the Bureau. Take the Bureau's verification letter and draft a second letter asking exactly how they verified the BK in the first place. Demand they specify who they contacted and what information was checked. For example, your letter says this case was verified with the court. By what process? Who contacted the court clerk? Provide the evidence of the actual matching of SSN and DOB. But guess what? That's kind of impossible if you were paying attention to what I said earlier. The bureaus must respond. This puts them on record. They will either back down or send you the dockets. Often they will mail you a copy of the case docket from Pacer, which has redacted data, mind you. Keep everything you get. Contact the bankruptcy court and judge. Now you have their claim. We verified with the court in writing. Write to the bankruptcy clerk's office and CC the presiding judge, stating that the credit bureaus insist the court verified a case in your name. Include copies of the bureau's letter and your previous dispute. In your letter, politely ask the court to verify that information for the bureau. Use certified mail as well. Almost always, the court will reply that they do not report any information to credit bureaus at all. This official response from the court saying they had no role in your credit report is a game changer. Send intent to sue to the credit bureaus. Take the court's reply letter and send it to the credit bureau, again by certified mail. Label it Notice of Intent to Sue and reference FCRA. For example, we have evidence that this bankruptcy entry on my file was not verified by the court. The court's clerk confirms they do not report to credit bureaus. Therefore, your continued reporting of the item violates 15 USC section 1681E subdivision B and 1681I by willfully furnishing false information. Remove the item within 30 days or I will pursue legal remedies. Cite the FCRA. Say the Bureau willfully and knowingly furnished false data in violation of 1681EB, the accuracy, and 1681I, which covers the dispute procedure. This letter leverages the court's own words. In many cases, the Bureau will delete the BK rather than face the lawsuit. Dispute directly with LexisNexis and LCI. Meanwhile, don't forget data providers themselves. You should also file disputes with LexisNexis Consumer Center, Equifax, and Experian Data, and with LCI's Consumer Center. Send them certified letters explaining the errors and attaching your court documents, and whatever documents you may have. Use their addresses. For LCI, it's P.O. Box 1582, Burlingame, California, 94010. For LexisNexis, it's P.O. Box 105615, Atlanta, Georgia, 30348. Cite the same legal requirements LexisNexis/LCI. LexisNexis are furnishers under FCRA 1681S2 and must correct or stop reporting errors. Getting LexisNexis to flag or delete the record helps ensure it doesn't just reappear. If LexisNexis or LCI find the info unverifiable, they will notify the CRAs to delete it, escalate it if necessary. If after all that the BK stubbornly remains, it's rare but possible, you can escalate further. File a complaint with the CFPB, naming the bureaus and furnishers. The CFPB takes credit report complaints seriously, despite of what you heard from other YouTubers. Alternatively, consult with an attorney who specializes in credit and FCRA law. FCRA allows lawsuits or willful violations with statutory damages, costs, and attorney fees. Focus your case on factual mismatches and the proof you've gathered. Many times, the threat of legal action is just enough for you. Here are some common mistakes to avoid along that process. Even small errors in your strategy can doom your efforts. Here are some pitfalls to avoid. If you're new at this, never just rely on online disputes alone. It sounds faster, but bureaus often just rubber stamp those or reinsert negative items without you knowing. But this isn't due to the faultiness of online disputes. It's merely based upon provisions in the FCRA, the Fair Credit Reporting Act, Section 611, 15 U.S.C. 1681I, outlines the process for disputing inaccurate or incomplete information on a credit report and mandates that the credit reporting agencies must investigate disputes within 30 days. So during this investigation period, creditors or furnishers are generally prohibited from taking adverse actions based solely on the disputed information until the investigation is resolved. This ensures that consumers are not unfairly penalized while the dispute is under review. So what may happen is that the negative account within question will just reappear on your credit report until some sort of response, whether that response be an ACDV or not. This will happen whether or not you dispute by mail or online, but if you want to have a bulletproof dispute attack, have a better paper trail and proof that you sent certified mail. Upon opening up online disputes online or by mail, the bureaus are required to send you a copy of your credit report and investigation results. Chances are that when you get your first response from the credit bureaus, it's an ACDV and not the response that I like, nonetheless acceptable by the FCRA. Oh, my bad. I didn't tell you what ACDV is. ACDV stands for Automated Consumer Dispute Verification. It's the eOscar form furnishers send back to bureaus. And that's kind of where I got inspired by my ACAT system, and partially inspired by Stephen Hawking's communication system. ACAT also is a communication system that talks to the credit bureaus. It's our in-house proprietary dispute AI software or cloudware that we use to get results like this. It stands for Automatic Credit Analytic Technologies, but that's for another video. Under the Fair Credit Reporting Act, creditors and furnishers and credit bureaus, CRAs, are legally required to conduct reasonable investigations of disputes And automated ACDV responses without human review or verification may definitely violate the law. Here's the breakdown of that. Let's showcase all the legal prohibition against automated ACDV responses. Number 1, FCRA 1681I, subdivision A 1A, mandates that CRAs must conduct a reasonable reinvestigation of the disputed items, which includes forwarding disputes to furnishers via ACDVs and verifying the accuracy of the response in writing. The CFPB Circular of 2022 of July also clarifies that furnishers and CRAs cannot avoid reasonable investigations by relying on automated systems or demanding unnecessary documentation. Even the Seventh Circuit precedent of 2023 emphasizes that the legality of a credit report's accuracy hinges on whether the ACDV response itself was properly verified, not the final report. So if you want to have a bulletproof dispute strategy, you can clearly catch them in the act and use it against them. In my experience, it's a great deliberate way to get some easy accounts deleted due to the above facts, if you know what I mean. Don't skip specialty reports. Many people don't even think to pull their LexisNexis or LCI report because it's not as seamless as, let's say, annualcreditreport.com or creditreport.com, or even the 3 credit bureau monitoring that you can find in the video description below. Those documents often contain extra details or errors that aren't in the credit bureau summary from the traditional reports that you get from third parties or just any other source like annualcreditreport.com, Smart Credit, or Credit Karma. If you don't see what LexisNexis has, you might miss a key error you could challenge. Not checking your specialty credit reports outside the 3 bureaus is like flying a fighter jet on a cloudy day without a radar or an altitude indicator and an altimeter. You'd have no idea of your orientation or altitude, making it nearly impossible to fly safely. And how could you eliminate your target without being able to view them on radar? That's the old school way of fixing credit, not the advanced way. Now let's take a look at what LexisNexis credit reports look like. All right, guys, so this is the LexisNexis consumer report that we have to get, and we just got to bypass the security. And it's actually good that the security is here because you don't want anyone to have easy access to this information. All right, so we want to choose the second report. I've requested both reports. We just put in the password here and confirm again that I'm not a robot. And we will choose this report and put the password in. All right, so this is the report. This is the beginning of it. Lots of stuff on here. I just want to give you guys an example. I know this is blurred out, but let me just kind of run through the report. It has pretty much everything about you. Identification, records, insurance policies, pretty much everything. This is like FBI type status. And I know this is blurred out. Don't worry, you'll be able to see what's on your report and how crazy this looks. But if you look at the stuff I'm seeing, it's pretty extensive. This is like I'm not joking. This is like FBI type level information about you. So if you haven't ordered your LexisNexis report, I think you should, regardless of whether or not you have a public record or not. Like I said, I'm looking at insurance records, driving records, phone numbers, ex-girlfriends. I'm seeing tons of different stuff on here. Phone number changes, name variations, mail, you name it, it's pretty much on here. It's kind of scary. And like I said, I'm scrolling down all the way to the public record, the bankruptcy section, because this particular person has a bankruptcy and he has a judgment in the state of New Jersey. So we're looking at the report. And just like I said, we haven't even gotten to the bankruptcy stuff. How many pages is this? 20 pages already? Let me see. Yeah, nearly 20 pages. And we haven't got to the public record section, which is like closer to the beginning of a LexisNexis consumer report. So let's keep on going. And I want to go through the pages. I don't want to skip anything just to illustrate
how extensive these reports are. So once we get to the BK section, I'll tell you exactly what to kind of look at. Now, this person is in a different court. You might be in California. This guy's in New Jersey. Each jurisdiction, it's a little bit different, but generally the format is the same. Okay, we made it. Bankruptcy section right here. I see the bankruptcy filing number, the bankruptcy case status, original bankruptcy is 7, the date it's filed, the court name, even the judge and the attorneys involved, and the petitioner, the case, the date of last update of the case ID, and pretty much everything. And right here is a civil judgment.
Okay, that was your LexisNexis credit report. Now what about ordering your LCI? If you want to know how to order your LCI reports, I've included instructions via a link on how to do that in the video description below. And for those of you that are more visual learners or just like looking at my face, there's a video you can watch here, or maybe it's down there. I'll let you find it. Be wary of goodwill requests or DIY hacks. Some blogs or even YouTubers suggest writing a simple goodwill letter to your creditors or just waiting. Inaccurate bankruptcies are a legal issue, not a favor to ask. And don't abandon the fight too early. This is the number one mistake I see noobs and amateurs make. Remember, we talked a lot about ACDVs and whatnot. Bureaus will likely deny or ignore you at first. Guess what? That's normal. The real progress often comes from after repeated escalation. Pinnacle credit being involved, court letters, or attorneys being involved. So keep your deadlines in mind. Under federal law, each dispute triggers a 30 to 45-day window for responses. Focus on objective errors, not legal disputes. Credit bureaus defend legal questions. As courts have held, FCRA isn't for arguing. Should this debt have been wiped out? If the issue turns on bankruptcy law, e.g., is this loan dischargeable, the Bureau may claim it's outside of their duty. Instead, argue the facts, such as, my name is John Doe, my birth year is 1980, case number 12-34567. That docket shows someone else's address, so it's clearly not mine. The Matter and Keller cases make it clear that only concrete factual mismatches give you a standing under FCRA. Document everything. Keep copies of all your letters, envelopes, and responses. If you hire an attorney later, you'll need proof you disputed and they ignored you. Even do your own mini trial. You'll send certified letters, and if you later sue, these are your exhibits. Bypassing these mistakes keeps you out of control. Remember, 1 in 5 credit reports has an error. Don't let this mortgage-style debt trap or wreck your credit score. Put it all together and get some help. You now have the full blueprint. We've covered every angle. Pulling your reports, finding errors, disputing with legal precision, involving the court, and even pressuring LexisNexis and LCI. We even touched on applicable FCRA rules like Section 1681I, Section 1681E, Subdivision B, and even 1681S too. In practice, this approach has helped many consumers clear erroneous bankruptcies and restore their credit. If you feel overwhelmed, don't hesitate to get some professional help from myself. Many law firms and credit repair attorneys work with me as well, and they specialize in these types of cases. For example, one credit law expert notes that if letters alone fail, they will take up your case pro bono or contingency. A lawyer can formalize your intent to sue letter, handle communication, and even file an FCRA lawsuit if needed. The important thing is, don't rely on shady companies promising instant fixes. And if the company is located in Georgia, like this one here, and has no verifiable address, they're definitely a scam. And you should reach out to a reputable attorney and a firm to use the same rules we discuss. Or you can hire my own company because we're pretty much just as good as a lawyer outside of the legal realm of the courtroom. And working with firms like my partners or myself, you'll have some real legal muscle. Okay, you've learned the steps now. Pull those reports, send in your letters, and keep all records. If that seems like too much to handle solo, reach out to me. I'll be happy to help. Disclaimer: this video provides general information, not personalized legal advice. For advice tailored to your case, consult with a licensed attorney. I'm not one. Always keep your own records and act promptly. Good luck, and may your credit report be accurate and fresh soon. I'll see you on the next one.